judgment of conviction or probation ordered in the state having jurisdiction over a criminal case, including those for set-asides. So even if your client's able to expunge an offense, that's still a conviction for the Sex Offender Registration Act, and they still have to follow all the rules. That's one of the reforms I'm really trying to have the legislatures look at and change, because if they don't have a conviction and a judge has found that they qualify or they're worthy of having their case expunged, why are they still on the registry? Also, if another convicted offense for SORA is getting HIDER prior to 2004, that's when it changed. Having an out-of-state adjudication, if it fits in our listed offenses. So you can look to see what is a listed offense. Also, always remember with your sexual offense cases, be leery of the catch-all provision. I talked about that a little bit ago, but if you work out a great plea bargain with the prosecutor where you get a CSC 3 case dismissed in exchange for assault and battery or felonious assault, if the victim is under 18, that person falls under the catch-all provision, and they still have to register. What the judge determines, and that's what that People versus Lee was about, where the judge has to determine, is this a case that's sexual in nature? I don't care. So be careful how your client pleads guilty. Don't just say no contest, use the whole police report, because then you're going to find something sexual in nature. Have a very specific plea. I always recommend for these kind of pleas, plea bargains, do a very specific plea of guilty, don't do no contest, with very non-sexual factual basis.
Cheryl, if the judge makes a determination that it fits within the catch-all exception using the, the all-to-all factors, what tier will it go in?
That's a good question. Tier 1, which is good, because Tier 1 offenders are non-public. That's one change they did. Actually, Ann Yanis just asked me yesterday, because she's arguing something in front of the Court of Appeals today. She needed to know that answer. It's Tier 1. So your catch-all provision, people, but so many attorneys miss that, and judges, and you think, well, I worked out a great plea bargain. Just be leery. If your victim's under 18, they're probably going to get catch-all. But if the judge doesn't order it sentencing, I think with People versus Cole, they're protected now. People versus Lee.
Can you do that as part of a COBS evaluation?
I like to do that. Matt was asking, can you do that as part of a COBS evaluation? If you can get a prosecutor on board, it always makes everything so much easier, because you can have at the plea, what I do to protect my ones that I get a good plea bargain, put on the record, Judge, we're all in agreement, me, the prosecutor, and the court, that this offense doesn't require sex offender registration, it doesn't fall under the catch-all provision, and if for some reason this person is placed on the sex offender registration list, you will allow me to withdraw the plea. And judges will do that. Oh, I'm like that.
You and I both know we've done good pleas in front of judges just to find the probation and try to register anyway. So
oh, yeah.
In giving a practice point, I would suggest we make sure the judge signs a specific order, not sure.
Yes, exactly. Thanks, Mike. Because, yeah, especially not so much in Wayne County, Oakland County, Oakland, they are on top of this when it goes, because what happens and how your clients get registered, you do the plea, they go get the pre-sentence investigation report. While they're doing the PSI, the probation officer's duty is to register your client. So by the time your client comes into sentencing, they're already on the list, because for SORA, it's the date of the conviction is your start date. So it's the plea. So that's why it's so important on the time of the plea, make sure your client's protected. Wayne County's pretty good. If they don't see an order, the probation department doesn't see an order for registration, they don't register them. Oakland, they're on top of this.
What about the problem that you talked about relative to when a person makes a plea, they don't mention the sexual aspects?
Right.
What happens with the probation department when they're putting in their statement of offense, which they're getting from the police reports? How do you prevent that?
That's a good point too. I would ask to strike it, because I don't know if a judge would say, Judge, my client only pled to this part, not all this other things.
What if you prepared a specific plea document that spells out what the parameters are, and that is to be directed to the probation department to be the statement of the offense, the factual statement of the offense?
I have done that in no contest pleas. I've written it up and said, this is what my client's pleading no contest to. Attach it to the PSI. Also, as Mike said, the order from the judge signed by the prosecutor, because prosecutors, a lot of times, are in agreement. They want this plea bargain to go through. So do everything you can to work together and send it to the probation officer so they realize, okay, this person's not supposed to register.
Don't take it from the police report.
Right. Yeah.
Because I've had to fight many a time trying to get the police report says something, but even the facts that came out during the course of the trial aren't that.
Right. So it's important too, at sentencing, look at the PSI. Because I'll tell you, I just had a case where I was, this is another real important to look at, the PSI and correct it at the time of sentencing, because I was just doing a Romeo and Juliet petition to remove a client from the registry in Oakland County. And it was true, I mean, it was 2-year-long high school freshman and senior dating relationship, family vacations together. She wrote an affidavit saying everything was consensual. This was the love of my life. We planned on getting married. And in the PSI, which if we don't have copies, it's almost impossible to get. So sometimes we are blindsided when we're doing it. I felt like I was. There was one part in the PSI where the victim's statement of facts, victim statement of the offense, for some reason, she wrote a handwritten statement at the time. She goes, I didn't want to have sex, but I didn't say no. So the judge in Oakland County took that. He says, how am I going to reconcile? This isn't consensual. Even though I had about this much evidence to show it was consensual, there was this one little sentence in the PSI, and the judge told me, I wasn't the original trial attorney, the judge said, why didn't the defense attorney strike that then? I said, Judge, I don't know. Even had the complaining witness come in and testify saying, Judge, I don't know why I wrote that. But I lost, and then I went back, and don't give up on these. The same day I did a rehearing, and he granted it. But it's important to look at that. Okay. So for the tier-based, so now how SORA is, it's tier-based. So you've got tier, oh, yep.
Granted the rehearing on what basis?
Because I kept trying. Really, I was just begging. I really want, I know, and he said, I had the prosecutor on board, which was, I was in Oakland County, I was like, wow, he's a gem. Really is a gem. Because he saw the logic. He's like, this is not a sex offender. The person is on the registry. That's why it's important to have a good relationship with prosecutors before you go in to do these things, because if they're on your side, you can get a lot. The judge actually said at the motion hearing, Mr. Prosecutor, I feel like there's 2 advocates here for the defendant. I'm like, yeah. And so when we went back to, I'd say, Judge, because the complaining witness came to court, because I didn't think she needed to be. I was like, I have an affidavit, I've got everything. That's another thing. Don't ever take these as a slam dunk case. They're not. If the complaining witness is in agreement, bring her to court. So then she was there. I had Judge Anderson grant the petition because he was on 2 separate charges. And I went back to the judge at the end of the morning docket and said, Judge, will you rehear it? We went back in chambers, and the prosecutor said, I agree, you can rehear it right now. So don't give up on these things.
Excuse me, you talked about your experience in Wayne and Oakland. Do you have any, or are you aware of how probation would handle it in Macomb County?
I think they're more similar to Wayne County, and so is Washtenaw. Ingham County is too. Ingham's really a good county for these kind of cases. It's Oakland. Do you agree, Mike?
I disagree with you.
Oh, do you? You think Macomb County is really tough too?
Not tough, it depends on the in-court probation.
What was that?
It depends on the in-court probation officer lot, and they are also very confused about it.
Yeah. That's true. Mike was saying that it depends in Macomb County on the in-court probation officer, and they're often confused about this law. I find that everywhere I go. With judges, prosecutors, probation officers, you have to be the most, like my dad was saying, the most informed person in the courtroom. Because a lot of times I've had prosecutors tell me one thing, I said, no, that's not right. Here it is. Out in Berrien County, I had to educate, about 8 years ago, educate a prosecutor. They can get HIDA for CSC3. They didn't even know that.
Did any of the changes, the recent cases, changes the ruling in Althoff that if it's contested, whether they have to register under catch-all, that the court does a hearing and looks at the underlying facts of the case? Is that
Right.
still, is that
That's
law?
still the case for catch-all provision. So you can have a big hearing, whether the whether the case was sexual in nature, and they usually are. You're usually going to lose on catch-all unless you get everybody to agree. Catch-all is very broad. So the tiers, tier 1, 2, and 3. Tier 1, and these are the tiering. You're like, how do you know if somebody's going to be in which tier? It's strictly conviction-based. That's it. And a lot of them go with the age of the victim. That makes a big difference. It doesn't matter if your client's a risk to reoffend. It doesn't matter. You can't have discretion. I hear that. Prosecutors can't say, okay, I agree to put him in tier 1. You can't do that. You can't have a judge saying, I'll do tier 1 for this. No. Has to go by what the conviction offense is. The clock for the registry starts at the time of the plea. Any period of incarceration, jail or prison, doesn't count for the Sex Offender Registration Act. So if your client does 10 years in prison, when he gets out of prison, then his clock starts. That's something new. A lot of people don't understand that one. Tier 1. So tier 1 offenses is the best one to be in. It's 10 years. It's non-public. You only have to go one time a year to go verify your information at the police. That's the local police department where the registrant lives. And the thing is, you got to remember, if you get a case, you got 2 counts of, let's see, tier 1 offenses, and I don't agree with this either. I was talking to Keith. Knowingly possesses child sexually abusive material, that's tier 1. And then we have CSC 3 with teenagers, tier 3. I don't see the logic in that. But people who possess child porn kind of got it made now because that's only a tier 1. But if you have 2 convictions for that, that'll make them a tier 2 because tier 1 only can have a single offense, single conviction offense. So it's important with plea bargaining. Make sure you remember that so you can get 1 conviction. If you get 2 tier 1 convictions, they bump up to tier 2. Same with if they get a subsequent sex act, that bumps them up to the next tier, whether they're in tier 3 or tier 2, they go to tier 3. So CSC 4, if victim is over 18, that's tier 1. Catch-all provision is tier 1. Sexually delinquent person is tier 1. So there's not that many. They're all listed on my handout on page 3. Tier 2 offenses. They must register for 25 years and they have to go verify their information 2 times a year at the police station. These are 2, you can just look at, I won't list them all out, you can look at my handout on page 4. And this is important to know, like CSC 4, if the victim's between 13 and 18, that's tier 2. So the CSC 2s and 4s and 3s are important to look at the age. Except actually the 2s and 4s are important to look at the age to see what tier they're in. Tier 3, which is lifetime. That's brand new, and if anybody here got calls from clients saying, I was 25 years, now July 1st I get a letter saying I'm lifetime. Hey, I've gotten so many. Like, I tell them all, be patient. Miriam Ackerman of ACLU and who was D. Piazza's lawyer is going to file a federal lawsuit saying it's a violation of the ex post facto clause of the Constitution. And there's great precedent from other states which said, yes, it is a violation of the ex post facto clause. So tell them all sit tight because it will apply to everybody if we're successful in that one. So you can give them a little comfort there. Because it's not fair. Can you imagine if you pled guilty, you thought you were going to register for 25 years? I have people saying, I only have 10 years to go and now it's life. Right now, I'd tell them I'll wait for Miriam because she is, in my opinion, one of the top experts in this and she will do a fantastic job. And if you have any, that's another thing, if you have any, because she hasn't gotten the class action yet, if you have any really good candidates,